Let's move on now. In what is being seen as a major setback to all political parties, the Supreme Court has struck down the National Judicial Appointments Commission, or the NJAC. The Supreme Court said that the 99th Amendment, which brought in the NJAC, that proposed to give more say to the executive in the judicial appointment, is unconstitutional and violates the basic structure of the Constitution. The commission was created by the government to be an alternative to the collegium system that has been in place for the last 25 years for appointing judges to the highest courts in our country. While the government argued that the collegium system lacked transparency, the petitioners who were opposed to the NJAC argued that the word eminent, as described in the amendment, was far too vague, and that would also encourage political interference in judicial appointees. The Supreme Court rejected the centre's plea that the petition challenging NJAC Act be referred to a larger bench, but also said that it was willing to take suggestions for improving the collegium system of appointment of judges, and posted the next hearing for the 3rd of November.
The court has held that this National Judicial Appointments Commission, in which the government would get a substantial say in judicial appointments, interferes with the independence of the judiciary and therefore has been declared to be unconstitutional. From now on, the collegium system gets restored, by which the senior judges select the judges.
Supreme Court today struck down the National Judicial Appointments Commission. Now, this is a decision that has divided, the judiciary in the country. They have been varying opinions. It has also reinforced its faith in the old collegium system. But what does this really understand? Let's understand this better in detail from Managing Editor Vinay Tiwari. Vinay, this decision, this verdict has split the judiciary down the middle. I was listening since morning to so many opinions from the judiciary, and as we can see now, what exactly did the Supreme Court say? Quote, that the NJAC encourages executive interference in appointments. So if you could just throw some more light about what really did the Supreme Court observe?
Yes, and to simplify it for our viewers, it's very clear. The Indian Constitution pretty much recognizes three arms of governance. One is the executive, one is the legislature, and the judiciary. Media is not part of the Constitution in terms of written word, but it's considered a fourth pillar. In any democracy, these three divisions work to create a democratic society. This particular debate in the Supreme Court and in Parliament was a lot about who exercises supremacy. The Constitution also spells out what is called the separation of power principle, which means the judiciary's power should be separate from the legislature's power. Very simply put, the lawmakers, which are the MPs of India, have the right and authority to make a law. The Supreme Court of India interprets the Constitution and figures out whether the law is legal or not. In this case, they believe that the NJAC is a violation of constitutional principles, and that's why they struck it down.
But why did they feel that? Why do you think that the Supreme Court felt that the NJAC was violative to the basic structure of the Constitution? Because I know that the political parties passed this overwhelmingly, it became a law, but then obviously there seems to be, some concern from the apex court of country that this would interfere in the appointment of judges.
Yes, and I think, again, a little bit of perspective for our viewers, this particular system, the collegium system, was in place only for 20 years. And ironically, most people perhaps do not realize that 20 years ago, the Law Minister of India used to actually participate in the process of selecting the judges. So there was a participation of the legislator earlier. Now, the Supreme Court believes that the NJAC's constitution includes members who are not judicial officers. There are two eminent people who are included as part of the panel, and these two eminent people could be anybody. And because there is a provision which says that two people can actually veto a decision of the entire panel, they believe that theoretically speaking, if two eminent people decide to strike down an appointment, it can technically be done. And they believe that this violates the principle of separation of powers, which means a person recommended by a judge or the court can be struck down by two eminent people who are not judges at all. And they believe this is something that is violative of the Constitution, which says judiciary needs to be separate from the legislature in all actions.
So, are you saying that the point of difference is largely emerged on the appointment of these two eminent citizens? Because one wonders that who will be these eminent citizens and who will be appointing them?
To be fair, Avantika, none of us have read the full judgment as yet, and the judgment is going to be very detailed, is what I presume. But from what we've heard so far from all the counsel, this is one of the points that the court found odd. Ironically, what we haven't discussed enough is who's going to nominate these two eminent people. And the panel which is supposed to nominate these two eminent people is going to be the Prime Minister, the Leader of the Opposition, and the Chief Justice of India. So a lot of critics have pointed out that in many ways the Supreme Court is questioning its own Chief Justice as not having enough authority or role to play in selection of an eminent person. So they believe that the selection should not really be a problem because you are party to the decision as well.
But tell me something, Vinay, I want to understand this. The NJAC was perceived to be a good middle ground. It was perceived to be, a balance of power. Now, if the Supreme Court has struck down the NJAC, I want to understand that why do they want, the collegium system to be relooked upon? Why do they want to bring upon reforms into that? Because in a way, don't you think that the Supreme Court is questioning the functioning of the collegium system also?
Yes, but unfortunately, like most things in a democratic society, apart from procedural and constitutional, there is also a perceptional problem here. We have to understand this whole tussle between the government and the judiciary has happened in the backdrop of two things. The last 3 years, there is an phase which is referred to as the judicial activism phase. The courts started intervening in a lot of executive roles. They started laying down policy decisions on behalf of the government. Not all of them went down with the government of the day because they believed the judiciary is encroaching upon their power to govern. It also followed a period where there was a slight hostility between the political class and the courts, because the courts were coming down very heavily in a lot of cases involving corruption and scams. Even in the passage of the bill, please remember that this particular bill was notified in April. And the passage happened in the winter session of Parliament.
The winter session, exactly.
At that point of time, there were already petitions challenging it existing in the court. And the court did not take it kindly, that the Parliament decided to exert a supremacy despite the fact that they know that there are petitions challenging the very existence of such a body. So it unfortunately became a bit of a perception problem. And I think both sides are now trying to draw the line of who can cross which Lakshman Rekha or not. The courts have drawn a Lakshman Rekha. They are saying you cannot do it. Not only that, they have today written that this order cannot be challenged.
But the question is that whether today's order, undermines the need for these much needed constitutional reforms. That has also been an ask from the judiciary itself.
One pertinent point, Avantika, what most people agree upon is that the collegium system was not working. If a system is not working, you have to find an alternate.
Right.
I think people have been surprised by the fact that the Supreme Court has struck down every single aspect of it.
Right.
I think people expected them to strike down some provisions and retain some others and then come and arrive at a consensus. That's not happened. They've struck down the entire thing. And that's what has surprised people, because they now believe that you're completely rejecting a system which you yourself and a lot of other people accepted was not working.
Which would have also probably brought about the much needed transparency into the collegium system. Well, Vinay Tiwari, thank you so much for joining us and, just sharing so much insight and giving perspective to a very important order that was given by the Supreme Court.
Thank you.
All right, and the Union Law Minister Sadanand Gowda has also responded to the Supreme Court's verdict regarding the National Judicial Appointment Commission. He has said that he was surprised by the verdict that has been given by the apex court of the country, adding that the government will now study the detailed verdict and will hold consultations with many legal experts before deciding upon their next move.
See, I was surprised by the verdict of the Supreme Court. I have not got the structure of the judgment. We have to go through in detail. Then again I have to discuss with my law officers, and I should discuss with my senior cabinet colleagues and the Prime Minister. Then we will decide what next step that we need to take.